Hello, and welcome everyone for on a new series of podcasts by the Black Silk on data laws and IT laws for businesses which are operating in India or businesses which intend to do business in India. I am KPS Kohli. I'm a partner at Certific Advisors, and today I'm joined by Ms. Debopama Roy. Debopama is General Counsel for a California-based technology startup called the Meet. She comes with extensive experience in handling technology, telecommunications, information security, data protection, mergers and acquisition matters across jurisdictions, especially the US and the EU, and of course India and other regions around the world. She has worked in India with many organizations, namely OYO, Brambles. She was part of Commonwealth Games 2020 in Delhi, 2010 in Delhi, and she has worked in US under various in various capacities. Devapama and I go a long way back, and I know that she is fascinated by the effect of information technology on the daily lives of individuals and their legal rights. This has led her to pursue her studies and do her master's from Indiana University, Merur School of Law. And in her free time, she understands and analyzes the impact of the AI and AML on legal and regulatory landscapes across the world. Devapama is well recognized for her acumen as a counsel and somebody who has experience across the world. She has recently been recognized with a number of awards, including the Indian General Counsel Award 2024 on a global peer-reviewed selection process based on a professional work achieved in the past year for her organization and her pro bono activities that she has undertaken, and her involvement in diversity and inclusion efforts in the professional life. She has been the General Counsel of the Year in the Software as a Service segment. She's a Ninja 9 awardee, one of the top 9 General Counsels in India, and she is the General Counsel of India 2024. So, welcome, Devapama, and thank you for doing this for us. I think because of paucity of time, I've been a little short on introducing you, but,
Thanks, KP.
and there are many more laurels that I'll have to add. But I mean, if since the podcast is all about IT laws and data privacy laws, so and you have worked across the jurisdictions, so if I may ask you, I mean, according to you, which, especially since you've been primarily doing telecom, IT, privacy, apart from of course others, because when
Hmm.
we talk about privacy, IT, and all, people think that we only do this, but IT involves a custom issues, especially for IT equipment, and we have been
Yeah,
discussing all that
yeah.
in the past. But according to you, I mean, primarily from a IT perspective, from an IT startup, and you working across the world, which according to you is the most comfortable jurisdiction as a GC to work in terms of IT privacy laws?
So, and thank you, KP, for the kind words and the introduction. And I take your a question on that. Working in a startup where you have business all across the world, and given the nature of the work we are into, product we are into, I guess it's a very giver question. Answer is that GDPR, the European Union. Because when you're working in the European Union, you have clarity on what you're dealing with, the laws. The laws are very clear cut, and they are very consumer, customer centric, data subject centric, individual centric. They are very clear about their rights for individual privacy rights. But nonetheless, also it becomes very easy for an organization, a multi jurisdictional organization where you're dealing with day in day out with privacy regulatory regimes across the world, to have clarity, because it gives a lot of clarity, and it's a very comprehensive law, which brings everything. It's like all the aspects are covered under the law. So if you are GDPR compliant as an organization, most of your concerns regarding other jurisdictions also get completely addressed. So if your compliances are totally done, you completed in you have less concerns regarding other jurisdictions when you are getting your business into. So that is my first choice, GDPR, and then followed by US definitely. But US has data protection laws in US and privacy laws are both federal and state governed. So those are very state specific laws are also there. But California being the state which has the maximum data protection and privacy laws, and over in US also, if you are compliant with the Californian laws, your half of your concerns are resolved regarding functioning in other states across the United States. So these are the two jurisdictions I would prefer, from a from a business standpoint and a lawyer, in-house legal a lawyer standpoint.
Right. So, well, of course, but I think US can also be very tricky at times, and EU can be sticky at times, I would rather say. I mean, there are certain situations where you're stuck, and but we'll probably get some time to discuss that.
Yeah.
But as a GC, I mean, what are probably the top 5 laws that you think that that you deal with every day? Top 5 of your head. What do you think probably top laws that you deal with as a global GC, somebody who works across jurisdictions?
So as a global GC who works across, it's first is the, I would say, I'll come from the Indian perspective, okay? The DPDP Act, which is right now been is on the verge of getting enforced in India, which comes first in my mind, followed by GDPR and CCPA and COPA and CPRA from Europe Union and USA. Along with that, if followed by that is the Information Technology Act and the Certain, because in AirMeet, given though it's a California-based startup, it's in the India-US trade corridor. So, as any other Indian startup, we are there in US, but then we have our subsidiary in India, and the majority of the employees, operations, research and development are based out of India. So we have to take care of Indian laws as well. So third is my Information Technology Act and Certain, and then my fourth is the intellectual property rights legislations laws, which in perspective to both India and USA, in respect to registration of patents and trademarks. And my fifth is the fifth, I would say, in Indian perspective, is the Companies Act, MSME, because we are a micro, small and medium enterprise. So these are the 5 topics which we have. We deal with day in day out as as an in-house counsel for AirMeet with operations in India and the US.
That's good. I mean, it's fairly large list. I mean, it's top 5, but I think you probably cover most of the operation requirements of any startup in India.
Yeah.
Especially the DPDP, the IT Act,
Yes.
the IPR issues, and of course the Companies Act.
Yes.
But DPDP itself has a bit of a, I would say, a history in India before it has now come in the shape that it is, passed by the Parliament. We have the first iteration in 2018, and then subsequent iterations. There have been some flip-flops. The first iteration, I remember, was debated a lot. There was a lot of pushback on the first iteration of the Data Protection Act, the bill that had come in 2018. But the 2023 Act, I think, is fairly reasonable and is well balanced. But I mean, if I may ask, what is your take on the TPDP as a whole? I mean, since you've worked across and you've seen and worked in various privacy jurisdictions across the world, how do you see? What is your primary take on the DPDP Act?
So, looking at the latest iterations of DPDP Act, it comes as a breath of fresh air for businesses or enterprise entities who wants to do business in India, because it brings a lot of clarity on how data should be handled of individuals. And DPDP, as you know, it definitely covers a majority aspect of GDPR, and also and other global regulations like in the US and also the Chinese regulation. Over and above that, DPDP has its own unique features also, which is kind of a added advantage given in perspective of the Indian scenario, social and economic scenario as well. So DPDPs, if I look into DPDP, my the applicability of DPDP, or the scope of DPDP, I would say extends not only to Indian citizens, but also to data being handled abroad by enterprises of Indian citizens, concerning Indian citizens. And also it is from a territorial jurisdiction point of view. It also it also is applicability is within the territory of India, Indian territory, where anybody who is any data data principal. The term is data principal instead of data subject, which is used in DPDP. The individual who is within the territorial jurisdiction of India, whether that person, that individual natural person, is an Indian citizen or not, DPDP shall be applicable. So the applicability brings a lot of comfort from a business point of view, and from an individual's point of view. I would say that it's quite broad, and it extends beyond the borders of India.
Right. Especially, especially when you give any service or sell any goods into Indian territory, then it becomes applicable. So that's where it is extra territorial application of the law, much like GDPR.
Yes.
But it's actually more territorial rather than an individual specific. So if somebody who works into India gives services into
Yes.
India, even if you have no business operations in India,
Yes.
But you give services into the Indian territory, then DPTP would be.
Yes, it's mostly of profiling of Indian citizens or residents, or even non-residents who are in India, who are doing you're doing their data profiling. So that applicability comes into picture, and that brings a lot of comfort from a right to privacy, of individuals, as per because we draw this act from our fundamental constitutional right, that the right to privacy under the Indian constitution. That's why.
Correct. And Supreme Court has also said it in Puttuswamy. That's why
Yes.
the act, the government started drafting it,
Yes.
and then it took them a few years. But I think the final product, as they say, it matters what comes out at the end. But final product per se, I think is quite satisfactory. The industry has taken it well.
Yes.
I think the execution, the implementation of the act is what is seen, what is anticipated. And we were anticipating it last year only, that government would come out with the rules, establish the authority that needs to be established, and get the act working. But that has not happened. But I do see that now that elections are due in May, so I don't see any traction happening on that scope. And what's your view on this?
KP, there are a lot of things, there are a lot of aspects in the act which are very dependent on the rules and the notifications coming from the government on the legislature. So, for example, I'll say, when you're talking about data fiduciary, the term data fiduciary, where we are using it instead of data controller, which is used in GDPR. Now, term data fiduciary has another subset called the significant data fiduciary. Now, the government has the discretionary power to classify a data fiduciary or a group of data fiduciaries as significant data fiduciaries. Now, those parameters are based on the volume of data being processed by that particular data fiduciary. It can be any data fiduciary. Now, those parameters, and the government has the discretion through notifications to classify them and to also bring, certain restrictions around those classifications or limitations. So those what we are, as lawyers or different stakeholders are looking forward to, because that brings a lot of clarity on how these things, these broad terminologies, definitions will be dealt with by the government, right?
Correct. Right. But okay, so that brings me to the probably next question I want to ask you. That since the act is yet to be put into action, I would say, although it's been passed by the parliament, and we know that this is the final letter of the law per se, but when it comes into operations, will comes into practice, we'll see how it is implemented. But what, according to you, probably are top five, top six important provisions of law as you see it, that would be quite important, that every business should look at, should be careful about, or should at least read it once, analyze it, how it is applicable to their business, and what are the steps that they need to take. So what, according to you, would be the five or six, whatever you want to name them, sections or provisions or chapters in the act that you think that are important and everyone should look at them?
So first, I'll look into the consent part. How consent is being dealt in DPDP Act, which is very important. In DPDP Act, the consent which is being dealt is basically where data can only be processed by the data principal, given that explicit informed consent or is given, or if the data is processed for legitimate uses defined by law. Now, legitimate uses defined by law has almost 8 or 9 categories of legitimate uses, that where it is given. So that's a very important part. And the good part is that they are not saying implied consent, they're saying explicit and informed consent. So that is a very pro individual right specific. It is good for the individuals who's the data principal. It's a very it's good for that. There's no ambiguity in that implied consent will be considered as a consent until unless it's under so it's a straightforward that you have express consent, then your data can be processed by the data fiduciary once the data principal gives the express consent. The second part to it is, which is very interesting, is the right to nominate. Now, right to nominate is there in other laws as well, and the right to nominate comes into picture where it has that somebody, the data principal is incapacitated. But under DPDP Act, given the Indian scenario, how because data is also considered to be a individual's property, right? From that perspective, you have the right to nominate somebody, and that can be exercised upon the death of that data principal, which is not there in GDPR. GDPR is very clear. The right to data, data protection or right to privacy, data privacy dies with the death of the data subject. In this case, that is not the case. When you're saying a right to nominate and that upon the death of that person, that means your right to data protection continues even after your death. That how is your data being handled will be also can be controlled or governed or monitored by the nominee of the data principal. So and that's a very interesting part to it. Now coming to the third. Yeah, go ahead.
Sorry. No, I was just saying that right to nominate, of course, is important. But I do see that since data is considered as an asset, or a unique asset or a product that a person is tied to. So if it is available to him while he's alive, I think it should be available to a person after he's dead, because as they say, dead people don't file any defense. So and they shouldn't be talked ill of. But I think that's a good provision. I think it's quite futuristic, especially. I mean, people can actually have full control over their data, and after that, their estate or their nominees will have full control over it. So, having this provision will make the IT service providers or people who collect personal data will be obligated even towards the estate or the nominees of the person who's no more, to actually treat the data accordingly as per the wishes or as per what the nominee tells them. So I think that's a very futuristic and
Yes.
uh, I really like the provision that usually what happens is that if somebody is using a social media, let's say, and is no more, then how do you access their account?
So do you know what? It's a very interesting thing, do you know, KP? What happens with Facebook and other social platforms when on their demise of a person, individual, that account after, you know, they have certain protocols to maintain and compliances to maintain, where they inactivate the account, right? And because the right to privacy dies out with that death of the person as well, nobody else can act upon, right? And there's a lot of I would say collection lot of such accounts or such data which is there in the internet, on the social media platforms, where it's they can't be dealt away with, they can't be erased, right? And they have certain provisions to kind of wait for a certain time period, and then the erasure or deletion can take place. In that case, it also helps on how much your data can be retained. So when this act comes into play, then obviously the entities corporation has to also look into the picture on their data retention policies, right?
Correct.
uh,
Correct, and they also have to probably give them an option to nominate somebody as
yes,
a separate in their application.
yes,
Usually, that happens with banks and
yes,
securities and everyone. So you do a separate nomination, and then probably while registering it, there will now be especially for the Indian market and probably for your company. I mean, when
yes,
you register somebody on your platform, going forward, maybe you'll have to give them one option in their registration
yes,
form to nominate somebody,
yes,
and and of course we'll have to figure out how you will grant them access. How will you ensure that
yes,
the access is not granted to the
yes,
nominee while the person is alive,
yes.
or is
Verification,
is not
authentication, yes,
incapacitated.
or verification or authentication also after the death or incapacitation. So how do you kind of deal with those are very crucial and very sensitive I think domain space, where the organizations have to deal with very sensitively, and they have to be very cautious about on the compliance part on this, on these issues. But yes, it's a very interesting thing, KP, because given that we have this practice in India where wealth passes on from, or property assets, it's owned through hereditary this thing, or through the through family owned this thing. We have the concept of HUF also, right, on the family law. So it will be very interesting to see when it gets implemented, and how this aspect of DPDP gets applied to our day-to-day lives, and how it impacts us. So it will be very interesting to see these applicability.
Absolutely, because I mean, at times, somebody's social media may have certain special pictures which gets locked away. I mean, certain vacations that you did
Yes,
with that person, maybe, and he's no more, but you can't access the pictures because now it was in his social media or her social media account, and that's locked out. So I think this provision will help the nominee to access it and decide what needs to be done.
yeah,
But on the consent also, I wanted to discuss, because probably that's one of the most significant and aspects of the DPDP, as you rightly pointed out, and probably that was your first choice
mm.
of the relevant sections. Because consent in India, I mean, I think the section is quite clear. Section 6, that, and it has to be free, specific, informed, unconditional, unambiguous, and in a clear and affirmative, and in a clear and affirmative action. So I think the legislation can't be clear enough in putting the words, and they have put in repeatedly the same sort of words to actually make it very clear that the consent in India is absolutely crystal clear, and the person who consent for how his data is to be used, you can't use it in any other way. So in practice, we'll see how it'll come by. As a consumer, I think it's very beneficial that how their data is used.
Yes.
But for a business with these 6 7 adjectives as to why, when you collect data, how it should be the neatest, cleanest consent, clearest sort of consent that
Yes.
you will get, and probably there'll be a there are certain areas in operations when we for businesses that even if you take consent, there are certain certain things that you can imply from those consent,
Yes.
even if it is clear and specific. But I think with added adjectives that the act puts in on, especially on the consent, I think it has to be exactly for the purpose that you have
Exactly.
taken a consent for a business. And if you want to use it for any other purpose, I think the businesses will have to go back to the customer again, ask for a clear, specific,
Absolutely.
unequivocal consent from them.
Yes.
So how do you see that in practice, and do you think that will add up to the compliance burden, or how do you think, because the act provides for when you take a consent you have to give a notice, so how do you think the notice should be worded? And I mean, any take on that?
So KP, that this the consent provision, when I was reading consent provision, I could see the reflection of our Indian Contracts Act, where when you somebody is giving you express consent, or when you are agreeing, how to give out, who can give a express consent and how can it be done, and so forth. So it has certain reflections of the Indian Contract Act, which I was very happy to see, because it's all the laws should be kind of on the same, they are all interrelated, and they are on the same line of thought by the legislators. Coming to that part of consent, what brings to the table for organizations operating in India or outside India, dealing with Indian data, Indian individuals' data, is that it brings a lot of transparency and accountability on table. And what I mean by transparency and accountability is that when you're obtaining consent, you have to be very clear, specific, to the point on what kind of data you would like to collect, process, and why would you like to process. So that brings a lot of you have to be transparent about your dealings with your data principles, and also accountability on what are you doing with that and to what extent. There is no gray area on that. And if there is any kind of doubt or any kind of change in that specific purpose for processing the data, then of course you have to inform, or you have to obtain a fresh consent. Now, whether you have to inform the data principal or not, or you have to obtain a fresh consent, that is the question. To my understanding, you have to all over obtain a fresh consent from the data principal if you intend to use the data already collected for some other purpose.
Of course. I mean, I agree with you, because
Yes.
if there's no concept of informing the data principal in the act,
Yes.
so either it has to be consent,
Yes.
and if you have any doubts as to whether I can use it for any other purpose, and if you have come so far as to decide that I should inform the data principal, I think rather than just informing, you should rather go for a consent, rather than leaving it ambiguous and informing them. So I absolutely agree with you, but on the other points, I think I've just looking at it, I think we are running out of time. We thought I asked you that we probably keep it for 30 minutes, and maybe I'll invite you over to discuss the further aspects if we couldn't finish, and I was sure that we won't be able to finish it. But what are your other points? Maybe we can leave our audience that maybe we'll come back and discuss those points. So consent you mentioned. You also mentioned on the
data fiduciary.
Data fiduciary. So what are your other key points that you probably would want?
My other Other key points along with the right to nominate is who are data processor out here, then who are data principal, because the terminology of data subject has been changed to data principal. That is also interesting. And also who are consent managers and how consent managers will be dealing with the data, what are their roles and obligations. So these are my key points from the DPDP Act, and I'm happy to kind of take up another session with you and Black Silk on the remaining of the points in this series and talk about it in detail. And in the meanwhile, I'm also happy to take questions from outside, whoever the viewers are, so we can touch upon those as well in the coming series podcast.
Perfect. Thank you so much, Debopama. And we'll await for the questions from the people. And on the next podcast, I'll take your time, and we'll probably come back together to discuss the points that you have said. Apart from that, there are other laws that you have rightly touched upon earlier: IT Act, GDPR. So probably we'll be happy to have those sessions going forward, and I'll see our audience very soon. Thank you, Debopama.
Thank you, KP. It's been a pleasure.